The Appellate Division First Department is now in session. Good afternoon and welcome to the Appellate Division First Department's virtual oral argument. I am about to call the calendar, but before I do that, I want to point out that today marks the first sitting of Justice Tanya R. Kennedy as a member of the Appellate Division First Department. Justice Kennedy is a graduate of the Cardozo School of Law and has had a distinguished career in the law. She served as an assistant corporation counsel and as the law clerk for the Honorable Barry A. Cozier. Justice Kennedy was elected to the Civil Court, where she became supervising judge of the Civil Court, New York County. In January 2016, she became a justice of the Supreme Court, New York County. We are delighted that the governor has appointed her to this court. We wish her every success in the years ahead. I ask my colleagues to join me in a round of applause for Judge Kennedy at this point.
Thank you.
I will now call the calendar. People versus Melvin Johnson. Appellant. You have to unmute your microphone.
I'm sorry, Paul Weiner for the appellant, Your Honor.
5-1.
Thank you.
Nathan Scher for the people.
5 minutes.
Thank you.
Corcoran versus the City of New York, submitted. Matter of Louis B. versus Jennifer L., submitted. Santana Lizardo versus the New York City Transit Authority, submitted. People versus Darrell McCoy, submitted. People versus Martinez, submitted. Paget versus Peter Cooper Village, submitted. New York Environmental versus New York City Department of Education, appellant.
Stephen Weinberg.
7 minutes. Respondent.
Julie Steiner.
5 minutes.
Thank you.
People versus Joyner, submitted. People versus Velez.
Allison Haupt.
5-1. Respondent.
Jonathan Cantarero.
5 minutes. Matter of William C. versus Cheyenne C. submitted. Thompson versus Thompson, submitted. Kahn versus the City of New York, submitted. People versus Hobbs, appellant.
Barbara Zolat.
6-1. Respondent.
Brett Ferguson.
6 minutes. People versus Molina, submitted. Federated Fire versus Extel West, appellant.
Andrew Richards.
7 minutes. Respondent.
Jonathan Krukis.
5 minutes. People versus Anonymous, appellant.
John Palmer.
4-1. Respondent.
Jennifer Westfall.
4 minutes. Clark versus City of New York, submitted. People versus Torres, appellant.
Benjamin Weiner.
4-1. Respondent.
Samuel Goldfein, Your Honor.
3 minutes. Board of Managers versus 141 Acquisition Associates, submitted. People versus Johnson. Appellant, as soon as you're ready, you may begin. I remind the attorneys to keep their microphones muted until their case is called for argument. I also remind the attorneys not to speak over the justices when they are speaking. This is our usual practice, but it's especially necessary when we're doing video conferencing. People versus Johnson, go ahead.
Good afternoon, Your Honor. My name is Paul Weiner, appearing for Melvin Johnson III. The police acted unlawfully for 3 separate reasons. First of all, when they ordered Mr. Johnson to stop, before they approached him, they needed a level 2 because of the highly intimidating and intrusive circumstances here. It was nighttime. The officers had made a visible U-turn and approached Mr. Johnson and Piniella from the wrong direction, and there was testimony that occupants of this same van had previously harassed them. This was clearly not just a friendly request for information, so they needed a level 2. And at that point, they clearly didn't have enough information for a level 2 or even a level 1. The only information they had.
What did they know when, Judge Friedman, I have a question. What did they know when they made the stop?
The only thing they know.
Approached the defendant.
This is before they approached the defendant, when they ordered him to stop. The only information they had was the officer's testimony that as he was driving by, he smelled marijuana from somewhere outside the vehicle. And even if we assume for a moment
did police officer Jurikowski also know that the defendant was a member of a gang?
He had seen that on the sweatpants, but that doesn't have anything to do, I would argue, as to whether or not he was smoking marijuana. And I also want to point out that even if we assume,
but he did testify that they smelled marijuana. Isn't that so?
He did testify that. First of all, even if that is true, there was nothing to connect my client to the marijuana smell. Since my client wasn't seen smoking marijuana, he wasn't seen with a cigarette. This was a New York City sidewalk, where there's marijuana smell is quite common. And also, if you look at the video, only seconds before somebody had walked by. I'd also like to point out that
when he approaches him, doesn't he also see a bag sticking out of his pocket?
Yes, but I'm talking about before he approached him. It was the order to stop while he's in the van. After he had made the visible U-turn and was approaching from the wrong direction, I would argue at that point they needed a level 2, and they didn't even have that, or even frankly a level 1 at that point. But even if the stop,
how does the you mentioned several times that he was pointing from the wrong direction. How does the direction of his approach affect our analysis of this?
I think the question here is, how intimidating and intrusive are the circumstances? And I think when you have a police car, remember it is nighttime, it's 9:40 at night. When you have a police car make a visible U-turn and approach the wrong way, that's a pretty intimidating circumstance. And especially when you put that together with the fact that there was testimony that occupants of this van had previously harassed them. I'd like to add that even if the stop was lawful, the search was not. First of all, they were not allowed to frisk my client for evidence of a violation, so they should not have been allowed to search him, which was even more intrusive. Second of all, this was clearly not a search.
Counsel, this is Judge Cohen. What's your support for that? Because isn't there a line of cases that in fact do say that you are allowed to do a search incident to a violation, arrest for a violation?
You can do a search incident to arrest, and you can be arrested for a violation. That's true. But the problem here is that this was not a search incident to an arrest. The arrest followed the search here. My client was only arrested because the officers illegally went into his pocket, found the marijuana, and then arrested him. So it wasn't a search. He wasn't arrested and then searched. He was searched and then arrested, and that's improper.
Tell the officer though that he had marijuana on him?
Well, he did say that. First of all, two things. I would say that he said, "Yeah, I smoke weed." I think that's kind of an equivocal statement. I'm not sure that it even establishes probable cause. But even if they had probable cause, they still didn't. They still should not have been allowed to search him. This was again for evidence of a violation, and it wasn't a search incident to an arrest. So maybe, again, I think that was too equivocal. I don't think they should have been allowed to, I don't think they had probable cause, but even so, the search is improper. And the last thing I want to say is the officer's testimony here, I would submit, was simply not credible. His story is that as he was driving by, he smelled marijuana from 10 feet away. You've got cars that are parked in between. I just think that is absurd. This was clearly a story that was made up.
Judge Friedman, doesn't defendant's own witness, Pinello, confirm some of the officer's testimony? That the defendant said that he had marijuana on him. So, and you know, we're faced with the situation, you say the officer's testimony is incredible, and yet in some important aspects, the defendant's own witness confirms what the officer said.
Well, it doesn't, Your Honor. We know that he did have marijuana because after the search, he did in fact have marijuana on him. So nobody's disputing that.
No,
Nobody
the
said
defendant said that he had marijuana on him as reported by the officer.
Right, but the officer's testimony was that he smelled burning marijuana, and nobody said that my client or anybody else was smoking marijuana. So even if he had marijuana in his pocket, which he did, that wouldn't support the fact that the officer, as he's driving a car by from 10 feet away, there's parked cars in between, would smell burning marijuana. Again, I would submit that is simply made up here. And for any of these three reasons, because the stop was improper, the search was improper, or because the officer's testimony was not credible, I would ask you to grant the motion to suppress. Thank you.
Do any of my colleagues have any further questions?
I do. This is Justice Kennedy. Just want to go back to the initial conversation with respect to the stop, because you indicated on page 16 of your brief that the smell of marijuana could have come from anywhere. But what about the additional evidence that your client was a known gang member located in an area that was prone for narcotics and drug activity, gang activity, as well as the fact that the officer saw marijuana sticking out of your client's pocket? Can you address that? Because it just wasn't about the smell. It was all of those factors.
Right. Well, initially, first of all, when we're arguing that initially when he was ordered to stop, the only evidence they had, this was before the approach, Your Honor. So the only evidence they had was the officer's claim that as he drove by, he smelled marijuana. So that's the only evidence they had at that point when they were still in the vehicle, or they were just getting out of the vehicle. They hadn't approached. The second thing with regard to the fact that he had the gang words on his sweatpants, excuse me, Your Honor, I don't see how that's connected to the fact that in an appreciable way to the fact that he is more likely to be smoking marijuana. I walk around the sidewalks all the time, and I smell marijuana all the time. And I want to also point out that if you look at the video, a woman had just passed by that very spot seconds earlier. My client isn't seen with a cigarette. He's not seen smoking in any way. So there's really nothing to connect him to the smoking. Thank you, Your Honor.
Any other questions by my colleagues? Thank you. Respondent.
Good afternoon, Nathan Scher for the people. May it please the court. Your Honors, the officer's actions throughout their encounter with defendant were reasonable. As Your Honors pointed out, while driving in a high crime area with a lot of narcotics and gang activity, officers recognized defendant, a member of the Block Boys gang based in the nearby Baruch houses. Defendant made his gang affiliation clear by wearing sweatpants with the words Block Boys across them. And as the officers were approximately 10 feet away from the defendant, they smelled marijuana through their open van window. Under these circumstances, it was reasonable for the officers to simply ask defendant some questions. As the officers exited their vehicle and approached defendant, the smell of marijuana became stronger, and Officer Yazurkowski, who was trained in the identification of narcotics, saw a Ziploc bag commonly used to packaged marijuana hanging out of defendant's sweatpants.
Many people use Ziploc bags, myself included, to package many things besides marijuana. He wasn't testifying that he saw marijuana in the bag. He just saw a Ziploc bag.
That's correct. But given Officer Yazurkowski's experience and training in identifying narcotics, the Ziploc bag stood out to him as something that was commonly used to package marijuana. And courts have found that plus a totality of other factors like we have here is enough to simply ask the defendant if he had marijuana on him. And when he did ask that question, defendant responded affirmatively, "Yeah, I smoke weed." The suppression court held and understood this to mean—
Well, that's not saying that he had, this is Judge Mazzarelli again, that's not admitting that he possessed marijuana at that time or was using it on that time. That's just sort of a general statement that that's something I do, I smoke weed.
Well, the officer asked him the pointed question, do you have weed on you or do you have marijuana on you? And defendant responded, "Yeah, I smoke weed." The suppression court understood that to be an affirmative response to the officer's question, indicating that he had marijuana on his possession. And as was pointed out earlier, defendant's own witness at the suppression hearing testified on page 66 of the suppression hearing that defendant told the officers that he had marijuana on him. And so it seems unequivocal that defendant was telling the officers that he had marijuana on his person. And at that point, the officers had probable cause to search and arrest defendant. And it didn't make a difference in this case, the order of whether the search occurred first or the arrest occurred first, as the Court of Appeals and this court have held previously that the search incident doesn't have to necessarily take place after the arrest. In cases where there was probable cause prior to the search and the search and arrest happened within a close enough period of time as to make them one event, both the Court of Appeals and this court have found that officer conduct of searching and then arresting to be reasonable. And here it's the people's position that the officers had probable cause after the defendant said that he had marijuana on his person. They conducted a search and immediately after arrested the defendant.
Do my colleagues have any further questions? Thank you. Mr. Weiner, response?
Yes, just a couple points. I just want to emphasize our argument here is whether the officers at the time they ordered the stop, as they were pulling up, before they approached, whether they were permitted to order him to stop. That's our first argument here. And at that point, the only, there's nothing about Ziploc bags or anything else. The only thing the only information that they had at that point was this marijuana smell. And again, my client wasn't seen smoking or anything, nothing connecting to him. So that's the first thing. The second thing is, in terms of the search incident to the arrest, it's true that there can be an arrest after a search, but there has to be an intent. There has to be an intent formed to arrest. And there's absolutely no evidence in this case that there was an intent formed to arrest my client. It was only after they went into the pocket, found the marijuana, that they decided to arrest him. Thank you very much, Your Honors.
Thank you. Thank you both. New York Environmental versus New York City Department of Education.
Stephen Weinberg.
Go ahead.
Thank you. Good afternoon, Justices Friedman, Kern, Kennedy, and Mazzarelli. On behalf of New York Environmental, we are asking that the court reverse the lower decision. New York Environmental serviced for the Board of Education and the Department of Education two multiple different requirements contracts. The complaint below was for monies that were not paid for services that were delivered in conjunction with what is called the AHERA contracts, which is Asbestos Hazardous Emergency Response Act for testing for asbestos, and then other contracts that had to do with bulk sampling of water and for bulk sampling of asbestos. Again, separate contracts. Very important because they have separate factual evidence as to what occurred between the parties.
Counsel, this is Judge Kern. Why aren't they both barred by the statute of limitations since it was more than a year since the right to make a claim for payment had passed?
Two reasons. One, the contracts were not complete. The AHERA contracts were not complete. Under the AHERA contracts, there has to be the submission of a management plan. The Department of Education had acknowledged that that there were invoices there were no invoices yet, but that there were problems with accessing the database. And while years had intervened, they were going to allow and work on reopening the database to allow New York Environmental to submit the management plan. That is work that was not yet performed. So under the AHERA assignments, the contract is not a contract where it ends on the closing date. The contract is a requirements contract where they're given assignments. And under AHERA, the right to requisition or invoice under each assignment is only after submission of the management plan and after acceptance of the management plan. So that never even accrued, and that was the error that was made below. And that is why the year had not passed. 11 invoices on other assignments that were given under the AHERA contract were paid after the closing date. There were 8 of those were more than a year after the closing date. The database was reopened in 12, and there was a request to reopen it in 14. The Department of Education, Mr. Orlon, who's the same individual that was recognized in Conquest, had recognized, while this may be taking too long,
so when you just, Judge Friedman, when do you say your right to payment on these claims accrued? When exactly?
The right to payment accrued, Justice Friedman, when the management plan is submitted and there's approval. In these cases, there was...
And what date do you say that was?
That did not occur. Under the AHERA invoices, the management plans were never submitted.
When did the AHERA contract expire?
The AHERA contract, which is the closing date, expired in 2011. There were extensions.
2009?
2009, yes, Your Honor. And then they continued processing invoices as late as 2014. Work can continue after 2009. 2009 is only the closing date, which is when the Department of Education can no longer give assignments under that contract unless it's renewed to New York Environmental. So it never accrued.
So basically what you're saying is that you have this endless doing of work, which never sort of comes to a conclusion, and the statute of limitations doesn't begin to run on any of these claims, and the right to payment never really arose.
In the case of AHERA, absolutely. Because what happens is, and it's the endless situation which is occurring here, is because the actions lie within the Department of Education. They're not allowing...
I mean, don't you think, and I don't mean you, I mean your client, don't you think that your client had to be really concerned in what seems to be this endless extension of time for these claims to be paid, when you have a provision such as the education law 3813 2-B and which allows you've got a really tight statute of limitations on this. You have 1 year from the right to payment arose. And now you've got a contract which expired in 2009, and all these years are going by and you're not getting paid. And you say, well, I mean, isn't your argument sort of bordering on an estoppel type of claim?
Well, it is, Your Honor, because that's exactly in the emails and the telephone conferences and the meetings that occurred. They made statements that the money is still in the contract, and they kept processing invoices even through 2014. And they kept, in the case of the other contracts, they kept on asking for the resubmission of the invoices, acknowledging that the work was getting paid so that those monies could be paid. In the case of Ahira, there were 11 contracts that were submitted after the closing date, 8 more than a year. That took care of a third. Our New York Environmental was relying upon the actions of the Department of Education in terms of their email communication, their telephone, their meetings, that they would continue to at least process these invoices for the work that was performed. Very often, in the case of the other contracts more so, there were errors in terms of the software program, in terms of the passport information, which is the contract information to process the change orders. So New York Environmental believed that the Department of Education was going to continue to work with them. And by the terms of the contracts, they believed that, again, in order for them to invoice Ahira, there had to be a submitted management plan.
You're relying on emails, Judge Friedman. You're relying on emails, are you not, which you say show that there was a continuing intention to pay. But aren't the last of those emails 3 years before this action was even commenced?
The last of those emails may, yes, but what occurred after that was the continued processing of invoices, including through 2014. And there was no indication that they would not process any of the invoices on any of the contracts on Ahira or the other contracts until after the resubmission of the invoices in 2016, that there was silence. That was the first time there was, that there was silence with respect to the submissions of the invoices.
Do any of my colleagues have any further questions? Thank you, Counselor.
Thank you.
Respondent.
Good afternoon, Your Honors. Julie Steiner for the respondents. This case is a prime example of how the statute of limitations is necessary in contract cases to provide finality, to make sure that the public fisc is not forced years after a contract is ended and years after a claimant is allowed to demand payment to prevent the public fisc from paying those stale claims. This is not a case, as New York Environmental is suggesting, where the city is trying to evade paying millions of dollars. As Your Honor, Justice Friedman pointed out, in particular, with certain of the invoices under the Ahira contract, things were done if you look at their notice of claim, the documents that they supported were all completed or all invoiced in 2009. There might have been one invoice that shows something was done in 2014, but again, here we are with a lapse of between 5 and 7 years before this complaint was served and filed, before this action was commenced. This is a prime example of how we need to have finality. The year arose from the moment they were able to legally demand payment, and that occurred when those services were rendered to the city. And everything that was annexed to their various notices of claim under each of the contracts, the dates were from 2009, even 2004, and there's nothing in the record that suggests that the city did anything in terms of the estoppel argument to prevent them from filing their claim or filing their invoices anytime sooner. In fact, the emails from 2009, 11, and 14 from the city to New York Environmental expressed skepticism that they might not even get paid. There was nothing in our emails to them that said, that's okay, we used to pay some things in the past, years later, don't worry about it, submit it when you want. There's nothing in this manner. Because they were warned that they may not get paid with these very late invoices, they should have acted a little bit more reasonably and have come to court here with more clean hands.
Ms. Steiner, they argue that you're equitably stopped from raising this statute of limitations defense because of your course of conduct. How do you respond to that?
First, the pattern or practice that they're claiming existed, that might have been with some older other invoices that they annex at pages 1130, 1132 of the record. But with respect to the invoices that they are annexing to their notices of claim now to say that we failed to pay and our course of conduct in the past should dictate what occurs now, no, because again, as I pointed out, there were emails from the city on these particular invoices. Forget what they're showing and prove that we might have paid something years later in the past. On these particular invoices, we emailed them and said, I don't know if you're going to be able to get paid for these late invoices. We don't know if you're going to get paid. We warned them on these instances, on these invoices. I don't know about what's going to happen. So what we might have done in the past does not dictate what we did in this particular circumstance when we were clear that they may not get paid. And that is clearly, this court, Justice Friedman was on the panel in Sotheby's in 2019. There needs to be finality here. As you pointed out, you cannot allow them to cry foul in what we did when they also needed to act reasonably. And when you have invoices from 2004 and even earlier, and now 2009, 2014, we're talking years that the city now is now going to be forced to pay years later, and that is contrary to the public policy. And also, I just want to point out, they claim that they were bumped off in the AHERA contract, the AHERA database in 2012. Let's assume that that is true and they were put back onto the AHERA contract. Again, there's a problem there with their actions. 2009 was when the contract ended. 3 years occurred between then and the 2012 bump. What were they doing in those 3 years? And then when they were put back onto the AHERA database, again, 2012 and 2017, another 5 years again of where things were not done on their part to show that they acted reasonably. This case is clearly a prime example of how we need to have finality. And given that they had a legal right to demand payment years ago, and not within that, nothing occurred in that 1 year before February 2017. These claims are barred by the statute of limitations, and the city and the public fist should not be forced to pay any money at this point. Thank you, Your Honor.
Do any of my colleagues have any further questions? Thank you both.
Thank you.
People versus Velez.
Yes, Allison helped on behalf of Ricardo Velez. As a first felony offender suffering with a significant mental disability, Ricardo Velez was offered and he accepted a 9-year sentence. That sentence, made by the judge most intimately involved with this case, balanced the nature of the crime with the overwhelming evidence of Mr. Velez's troubled background and his significant cognitive limitations. Because Mr. Velez—
Judge Friedman. So Judge Solomon, I believe it was Judge Solomon, yes. Judge Solomon finds that he does not feel he can take the allocution as being provided by the defendant. After that session where the plea doesn't end up going through, the case was on in court 2 more times, right?
Yes.
Yeah. At either of those occasions, the defense counsel come to the judge and say, look, we were trying to do a plea at 9 years before. We'd like to have that plea.
So first, on the very next court date, which is September 25th of 2017, defense counsel did not even appear in court. In the record, there's a notice of trial engagement from counsel that he wasn't even present there. So nobody was available to negotiate any sort of plea on Mr. Velez's behalf at that court date. The case was on one more time. At that point, it seems like no plea negotiation was discussed at all. Nothing was ready for trial. But on the very next date, the first time—
So counsel didn't come to the court and say, look, we were interested in a plea. We started it. We're ready to go forward today with that plea.
On the one appearance in between when
Yes.
counsel was there, it doesn't appear
Well,
that there
all
was
it
any
would take,
discussion.
it doesn't need more than one appearance to effectuate the plea.
Certainly, I mean, at that point, first, Judge Solomon adjourned it for trial, making it seem like plea negotiations were no longer on the table. Yes, he did not have a conversation on that one date, but on the very next date, he did try and take that 9-year
What
sentence.
you're telling us today, in effect, is the defendant wanted that plea. So what better time than before you're setting a trial date than for the counsel to come to the court and say, we want that plea?
The issue here is, yes, he could have asked on that one date for the 9 years. He didn't, but he did ask on the very next date. And their issue here of fairness is twofold. One is the fact that Mr. Velez did try and take that plea in good faith. And the only reason that he wasn't able to take it was because he wasn't able to articulate the specific type of gun he used, which is certainly not an element of the crime.
I don't think that was the only thing that bothered Judge Solomon. It seemed like in the colloquy before that, he wasn't too happy with the responsiveness of the defendant to his question.
Well, first, I would say that even the trial prosecutor admitted that the reason that the plea didn't go through was because Mr. Velez wasn't able to explain the type of gun. That's on the page 6 of the sentencing minutes when the prosecutor admits that that's the reason that the plea didn't go through. So even she acknowledges that that's the issue. Second, if you look at the proceeding, nothing that Mr. Velez did was wrong, would be problematic. He took some time to answer questions, but that's unsurprising. Mr. Velez is somebody who's considered, based on all the documentary evidence, as borderline mentally retarded with an IQ of 73. It's going to take him some time with his cognitive limitations to maybe process the questions, or process what's being told to him. But every time a question was asked of him, he was able to answer yes, he was able to be appropriate and responsive.
But you say that this slowness doesn't seem to be a problem at the time that he actually takes the plea.
Though there are pauses at the time that he takes the plea. If you look at that transcript as well, there are pauses. It takes him time. It's clearly that he needs time to process the questions. He needs time to consult with his attorney. That's the same with the plea before Judge Farber. And certainly there were no issues that Judge Farber saw with going forward with the plea. And so I'd argue actually that the same exact thing happened in both cases. He was slow to answer, but he was always responsive. And in fact, even before Judge Solomon, he was able to allocute to the elements of the crime, even in his own words. So there's no concern that he didn't understand the nature of the charge, that he didn't understand what he was pleading guilty to. And the trial prosecutor acknowledged that by acknowledging that the reason that the plea didn't go through was because he did not know the specific type of gun at issue here. And it's not surprising.
Your time is running out, so
I would just say if we talk about fairness here, the issue here is not just that he wasn't able to accept the plea that he wanted to do, but if we look at the entire picture, if we look in context, the 9-year sentence is fair.
Counsel, when you look at the entire picture, this is a crime of incredible cruelty and brutality. He shoots that person who's in an apartment, had a right to be in the apartment, and then he doesn't let him seek medical attention for more than 30 minutes. I mean, that person could have bled to death.
Of course, the conduct here was inappropriate. Of course, there was damage done. Of course, there was this serious physical injury. That's an element of the crime. Of course, he made a mistake. But behavior responded in his papers attempts to paint the decisions that Mr. Velez made as ones that you or I would do. But unfortunately, Mr. Velez is not in the same position to make the rational choices that other people make. And that context is important to consider. That he's been diagnosed with pervasive developmental disorder, which is a disorder where one's ability to regulate behavior and emotion is impaired, where aggression and emotional breakdown is likely to occur. And that's what we see with the facts in the case. And that paints a different picture of moral culpability here, that he's somebody who suffered incredible trauma in his youth. All of the adverse childhood experiences that we know based on research lead to violence perpetuation. And it's somebody who never received any sort of treatment in adulthood. And what we do see in the record is that when he did receive treatment while incarcerated at Rikers, he did remarkably well. Counseling, prayers.
He was 39 years old at the time of this crime.
Right, and for all of that time, he didn't receive any treatment for his paranoia, for his depression, for his suicidal ideation.
Counselor, if I can stop you, do any of my colleagues have any further questions?
Yes, Justice Kennedy here. Just want to go back to the circumstances because Justice Farber did take into account your client's significant mental history. Matter of fact, he noted that on pages 16, 19, and 20 of this sentencing transcript. And the fact that the maximum sentence was 25 years and he received more than half of that sentence, how can you say that it's excessive? In addition to the fact that 4 surgeries, a partial foot amputation, forcibly entering the apartment, waiting more than 30 minutes, I should say, preventing the victim from calling 911 for more than 30 minutes to get medical attention. What about that?
So first, while the maximum sentence may be 25 years, the minimum was 5. And so he got almost triple the minimum available. This was his first felony offense. He'd never before been convicted of a felony, never did upstate time, had 2 misdemeanors from years before this incident occurred. And so you can't only look at the maximum, it's also almost triple the minimum.
Counselor, 5 to 12 is triple?
I said almost.
5 to 12 is almost triple?
It's more than double.
It's more than double, but it's closer to double than to triple. Anything else from my colleagues? Thank you. You have time in response. Respondent?
Thank you, Your Honor. Jonathan Cancerero for the people. As Your Honor had alluded to, it's not just the extremely violent nature of defendant's crime, it's also the calculated nature of his offense that undercuts any claim by the defense that a 12-year sentence was not appropriate, as the sentencing court acknowledged that it was an extremely reasonable offer, and also undercuts any argument that his purported mental health history somehow minimized his culpability. It wasn't just that he broke into his ex-girlfriend's house with a gun. It wasn't just that he calculatedly looked through each door, or I should say looked for her supposed paramour. He shot someone at point blank range, staying there for half an hour, picked up shell casings before leaving, and to add insult to injury, stole the victim's sneakers. To the extent the defense argues that his mental health was somehow related to that, almost all those arguments are based on the pre-sentencing memorandum, which was already before the court. As Justice Kennedy indicated, the court reviewed that and acknowledged it, and nonetheless said that the sentence was extremely appropriate. And at the end of the day, it's not Judge Solomon's sentence offer that this court is reviewing. It's the sentencing judge's imposition of the sentence based on the facts that were before him. 2 judges can disagree, particularly in this case where it was before a different prosecutor who had additional time to review the evidence.
Counsel Judge Friedman, this plea was taken without, am I correct, without the district attorney's agreement?
That's correct, Your Honor. It was over the people's objection. They were actually seeking a much higher sentence at both stages, both before Judge Solomon and before Judge Jackson and Judge Thomas Farber. And to the extent that the defense argues that somehow the defendant was prohibited from taking the earlier plea, that argument fails for several reasons, as the court has noted. He had 2 separate opportunities. He could have spoken with counsel and said, at the next court appearance, please let me take that plea. I want to take that plea. But even aside from that, when we speak about fairness, it would have been extremely unfair for Justice Solomon to have seen how the plea allocution was playing out and not stop the proceedings. He was, in fact, doing defendant a favor and letting him get his wits about him, consult with counsel if he needed to. And that's exactly why when he took the plea before Justice Farber, there was no issue. He responded quickly to each question. It wasn't just that he couldn't identify the gun. He couldn't answer the first question of whether he was willing to say the whole truth and nothing but the truth. And to the extent defendant argues that he might have just needed the question repeated, obviously Judge Solomon was in the best position to make that assessment. At the end of the day, it was an extremely violent crime, and the sentence was extremely appropriate. And for those reasons, this court should decline the invitation by the defense and by the defendant for a further reduction in his sentence. Thank you.
Thank you. Any further questions by my colleagues? Appellant?
Yes. When we look at the facts of this case, it's easy to call his behavior calculated when we view it only through the lens of what a rational person would do. But it's impossible to do that in Mr. Velez's case. We have somebody suffering from paranoia, somebody who's unable to understand the appropriate way to respond to complex adult relationships. That doesn't erase his responsibility in this case, but it places it in a different context. And when we fashion a sentence, part of the role is to look at mitigation, to look at moral culpability. And culpability is different when somebody is suffering from the issues that Mr. Velez is suffering from. And when your honors say that Judge Farber already took that into account with his 12-year sentence, I actually disagree. And that's because Judge Farber made it very clear that he didn't feel comfortable offering a plea at the point at which the case came to him, and that he felt constrained by the last offer made in Tab A. And that was the 12-year offer from Justices Biden and Jackson, which clearly were based on the new information that prosecutors argued were about the injuries. And so it's impossible to say that all of the mental health issues were considered in the 12-year sentence when that 12-year sentence was really about the injuries and not looking at the full picture. Judge Solomon did look at all of those things and was willing to offer 9 years, even as low as 7, but no higher than 11 when he made that offer.
But the injury picture had changed after Judge Solomon's offer.
Well, I'd argue not as much as the prosecution suggests. Judge Solomon was well aware of the partial amputation. Judge Solomon was well aware of the fact that there was conversation of a hypothetical amputation, but not one that actually came to fruition. And the information, as we argue in papers, about the extent of those injuries was not exactly as forthcoming. There were other issues at play here. Other delays in treatment, other injuries that it didn't, if not exacerbating the injuries, certainly extended and delayed treatment. The other surgeries because of unrelated assaults that the complainant was engaged in. And so I'd argue that the information about medical issues were far grayer than presented by the prosecutor, and therefore unfairly ratcheted the sentence up to 12 years. That the fair sentence would be the 9 years that Mr. Velez attempted to take, and that properly considers both the nature of the crime and his personal characteristics.
Do any of my colleagues have any further questions? Thank you both. People versus Hobbs. Appellant.
Yes.
Go ahead.
May it please the court, Barbara Zolot for Appellant Martin Hobbs. Your Honors, my client's conviction for first-degree robbery for displaying what appears to be a weapon must be vacated under this court's weight of the evidence review. Under the relevant robbery subsection and the court's charge to the jury against which the elements must be measured, the evidence needed to prove beyond a reasonable doubt both that the perpetrator consciously displayed something that could reasonably be perceived as a firearm, and importantly, that the victim did perceive the thing displayed as a firearm. The weight of the evidence fails to prove beyond a reasonable doubt.
What did the victim say? Didn't the victim say something like that she wasn't going to wait around in terms of whether it was a gun?
The complainant said that, but that has to be taken.
She thought he had a gun.
No, she never said she thought he had a gun, Your Honor. I'm going to direct Your Honors to where she said that, which should be taken in context.
But she said she wasn't going to wait around to find out. She
said that, but that's not the only thing she said.
Didn't your client? This is Judge Mazzarelli. Didn't your client say he had a gun?
The perpetrator said he had a gun, but what's significant about that is we know words alone certainly aren't enough to prove display, but what's significant there, Your Honor.
But didn't he also press a hard object against the victim?
Which the victim was unable to ever say felt like a gun, that she thought it was a gun, that she believed it was a gun. She never used the word gun. And getting back to Justice Friedman's point.
She said, I chose not to chance it, didn't she? I chose not to chance that.
When the court said,
say to him, show me your gun?
Your Honor, what we're saying is that although the display element has been broadly interpreted, it's stretching that element beyond what the case law has found appropriate, where the complainant never uses the word gun in describing any aspect of her sensory perception. When she said, "I chose not to chance that," the court, because the prosecutor tellingly never asked a question that would have elicited whether she thought it was a gun or not. The answer would not have been forthcoming.
Well, you had an opportunity to cross-examine her. You could have elicited such question.
What came out on cross-examination was what repeatedly came out, that it could possibly be a finger, which again, when she said, "I chose not to chance that," the court was following up on the absence of any real testimony during the direct and says, "Can I just ask you the object?" And incidentally, the complainant never called it an object. The prosecutor did, the court did, the complainant never did. "Can I just ask you the object that you said you felt? Can you describe what you were feeling again, please?" "I felt something poking my side." Could it have been a finger? From the court. It could have been, "I chose not to chance that." She chose not to chance that it wasn't a finger. That doesn't prove beyond a reasonable doubt that she perceived that it was a gun, where she never introduced the word gun into her sensory perception, into what she perceived. Given opportunities, she did not. Now, again,
why isn't this enough for her to reasonably fear that he had a gun based on the evidence, which is the legal standard? Why isn't it enough based on the testimony that she had a reasonable fear that he possessed a gun based on him saying he had a gun and pointing something at her?
Because what was required under the court's charge is that she actually did a subjective requirement, that she did perceive that it was a firearm. And the evidence here falls far short of what this court, in assessing other cases where this argument has been made. This court has expressly stated in cases such as Garcia, Groves, and Harleston that the victim specifically testified that she or he thought it was a gun, or that it felt like a gun, or that it was perceived as such. And yes, as my adversary will certainly point out, there are cases where, because it's an unseen item, the victim can't say specifically whether it's a gun or something else. But even there, the proof far exceeds what's here, because the victim there still gives concrete testimony that it could have been a gun, or it might have been a gun. That's lacking here. First-degree robbery is a statute that is meant to penalize the most serious of robberies, where there's a genuine risk of death or serious physical injury. And I think below at trial, everybody realized it. We feel confident in saying that. And today on appeal, I don't think my adversary would dispute that there was no weapon involved here. My client was a homeless man who had been arrested 2 days before for having an unlit marijuana cigarette. He was feigning a gun with his finger, and yet he's serving 20 years to life for that. A sentence that the judge below agreed was absurd, said was absurd. The judge below said this could not even be termed a violent offense. To take this element that the law has broadly interpreted, agreed, but to take it beyond where the case law has taken it before, to now find a first-degree robbery where certainly there was no gun involved, and where the complainant herself was candid and honest enough to never say, "No, I thought it was a gun, I believed it was a gun, it felt like a gun."
Counselor, your time is up. If there's something else you want to turn to quickly, I want to give you that opportunity, or I want to ask my colleague. Yes, is there something else you wanted to say before I ask my colleagues any remaining questions?
I would certainly like to direct Your Honor's attention as well to the competency and issues in this case. My client was examined on 5 separate occasions. On 2 occasions, he was not found competent. On other occasions, he was. But the issue of whether he could assist in his defense, given his long history of mental illness and this fixation, this personality disorder he had, where it came to the ability, the capacity to cooperate with counsel, makes it clear that he was not fit to be prosecuted for this crime. He did not attend the trial, and yet he stands sentenced to 20 years to life. We shouldn't take the chance that this mentally ill man was not competent to be tried, where he is now serving a life sentence.
Do any of my colleagues have any further questions?
Justice Friedman, I do have two questions, if
Go
I may.
ahead.
Thank you. Counsel, this is Justice Kennedy. And my first question to you is, how can you argue that your client was unfit to stand for trial when the evidence indicates that he understood the different functions of the judge, the jury, counsel? He discussed the differences between going to trial, taking a plea, also that he needed an attorney and would consider the advice. Also, the fact that Kirby would be a better alternative. So can you explain to me how this does not cut against your argument that your client was unfit to stand trial?
Your Honor, the question here has never been Mr. Hobbs' intellectual deficit or inability to understand the roles of the various players. It is a very specific issue here that Dr. Owen, who saw him interact repeatedly with counsel, spoke to so cogently, that he was unable to form a working relationship with counsel. It was, as she said, the actual diagnosis is almost irrelevant. What is seen throughout in every examination, in all of his interactions with counsel, which counsel herself, who tried very, very hard, attested to, they were unable, he was fixated on this relationship with his lawyers, and he was unable to assist in his defense. Whether it was a personality defect or something we don't have a name for, there was a way to treat it that was never tried. Cognitive therapy combined with potentially a change in medication, which counsel alluded to right before trial. Yes, he understood the charges. Yes, he wasn't mentally deficient, but he was unable to form a relationship with counsel or assist in any way in his defense or in strategizing about his defense. And the result is that no lesser included offenses were charged, for example. He was unable to cooperate with counsel.
Thank you. And my second question, I want to know how People v. Jordan is really controlling, because unlike here, the record in that case had disclosed continuing and essentially undeviating medical testimony of the mental incapacity. And one of the doctors who indicated that the defendant was competent to stand trial said that was based on his desire to terminate the defendant going back and forth from court to jail. So how does that case fit here? Because I think it's totally an opposite here.
Your Honor, it's instructive in certain, it's different in certain ways, agreed, but it's instructive in other ways, because what this case comes down to is, was this a volitional choice by Mr. Hobbs to not assist in his defense, or was it something that was beyond his control? And Jordan, where there was that question as well, held that the fact that one doctor said he could choose to was not enough to decide that he's competent. And this notion of not wanting to shuttle him back and forth, well, we have something similar here where the court, understandably frustrated, said this has been going on long enough. We're just not going to keep, going on and on with these 730s. And that's similar to that inadequate reason of the shuttling back and forth. The fact that it may require another 730, it may require a different modality of treatment, isn't enough to say enough is enough, we're just going to try this person, when we had such credible evidence from the lawyer, who was very credible, and Dr. Owen, that he was unable to assist in his own defense. So although Jordan is not on all fours, there are certain aspects of it that parallel this case.
Thank you.
Thank you. Respondent?
Yes, Brent Ferguson for the People, and may it please the court. Your Honors, I'll start on the weight of evidence issue. On that point, the law is very clear. The jury verdict must be upheld if the jury reasonably inferred that the victim was in fear of possibly being shot. And of course, the reason that that's written into the law is not the genuine risk of harm only, but the fear that it creates when a defendant, when he or she makes it seem as if he or she has a gun under his or her shirt. And that's exactly what happened here. Now, what's instructive is the defense can't point to a single case in which this court, or I think any in the appellate division, has reversed a jury verdict because the victim was unsure whether something displayed was a gun. And if you look at the context of the victim's testimony here, it was very, very clear that the jury was correct to infer that she was afraid of a gun. Now, the defense focuses on the fact that she used the word finger and that she didn't use the word gun when describing what was pressed against her. But she used the word finger only in response to defense counsel's and the court's question about whether it could have been a finger. And that, of course, isn't really relevant here, whether she believed it could have been a finger, because the question is whether she thought it was possibly a gun. And she did use the word gun when she was describing what the defendant said when he approached her and pushed something into her side. And she told the court that defendant said, "I have a gun, I have a gun." And of course, that provides important context for her other comments. I would like to direct you to page 49 of the record, which I think is the most helpful for the court. Defense counsel is pressing her on whether it could have been a finger that's pressing into her. And she says, yes, it could have been anything, but there was something pointing and he said he had a gun. That's clearly intending to show that she believed that he might be telling the truth, that he had a gun. Now, that combined with other testimony that she was frightened and that she said the object was not sharp enough to be a knife, all shows that she believed that there was some good chance that he was telling the truth and she was in fear of a gun. Of course, you can combine that testimony with her totally submissive conduct, which this court has said in Bynum is additional evidence of a display. And of course, if she believed that what he was pushing into her was just a finger, she likely wouldn't have immediately given him the money. But she gave him the money without waiting a beat. And that's, of course, because she said she felt fairly frightened. And if you look at the words in the case law, of course, some cases talk about testimony where the victim specifically says the word gun, but some don't because it's not necessary. In Lopez, the Seminole Court of Appeals case, the victim said that the defendant had a hand in his shirt as if he had a gun, but didn't say that he believed it was a gun. The victim didn't say he believed it was a gun. And in Bynum, it was a cylindrical object that the victim described. These cases and others show that it doesn't matter if the victim uses the specific word gun, it matters the context. And it would be truly inappropriate here to say the jury was not allowed to look at that context. Now, if I can briefly, Your Honor, just turn to the competency point. I know I don't have much time left, but what I'd like to say is that the important point here is that there were 9 examiners that saw a defendant in the 2 years before trial, and 8 of those 9 found that he was fit to stand trial. The only one that didn't was the defense's hired expert. Now, the defense tries to focus on saying that we can only believe the examiners that saw a defendant when he was sitting next to his attorney. Now, I'd like to correct the record quickly on that point. In defendant's opening brief, he argued that none of the neutral examiners saw him alongside his attorney. We pointed out in our brief that that's incorrect. Now, in the reply brief, the defense argues that only one of the neutral examiners, Dr. Gray, saw him with his attorney. That's also incorrect. The record makes very clear that both Dr. Gray and Dr. Arias sat with defendant and his attorney, and they both found him fit to stand trial, and they both thought that he was likely feigning his symptoms. Now, even if we only looked at those 2 neutral experts, that would still outweigh the 1 defense hired expert. But it's appropriate to look, of course, at all of the 8 experts in the 2 years before trial that are, of course, aware of this problem of defendant's lack of cooperation with his attorney, and they could take that into account when deciding that the defendant was refusing to cooperate simply on this issue and feigning his symptoms.
Any questions by my colleagues? Thank you. Appellant, Ms. Soloff?
Yes, I've reviewed the 730 reports, which are voluminous. My adversary may be correct about Dr. Arias as well. I can't speak to that at this moment. But whether it's true or not, what matters here is that there were multiple 730 exams, including the 2 that my adversary doesn't mention in 2012 and 2013, where psychiatrists twice found that Mr. Hobbs was not competent, citing many of the same things that Dr. Owen and defense counsel both observed as trial approached, which is this paranoia and this delusional relationship where counsel was concerned. So there were two that found him unfit. Others found him fit. But to dismiss Dr. Owen, who did see Mr. Hobbs repeatedly with counsel, including right before trial began, the examiners who saw Mr. Hobbs with counsel, that was months before trial began. But on the eve of trial, there was extensive a recounting of Mr. Hobbs's condition, where he was not even answering counsel's most benign questions, like where are your glasses or how are you doing today? Right before trial, he was unable to have even the most basic relationship with counsel. And counsel said repeatedly, he won't work with me. He won't talk with me. There is nothing constructive that we can do here. And Dr. Owen said this was not volitional. This was a personality disorder, which interfered with his ability to work with counsel, and that required treatment and medication. So again, his fitness, which it was the prosecution's burden to prove, was not proven. And there is a grave risk that someone who is not fit and who has an undisputed history of mental illness was prosecuted where he wasn't even present at trial, convicted of a very serious crime, and is now serving a sentence of 20 years to life. And we ask this court to review that closely.
Do any of my colleagues have any further questions? Thank you both.
Thank you.
Federated Fire versus Extel.
Yes, good afternoon, Your Honors. Andrew
Appellant.
Richards for Appellant.
Go ahead.
Yes, may it please the court. This is another delay damage claim where we're turning on a pleading. It's not a motion for summary judgment, it's a pleading. What we're talking about is the sufficiency of a pleading. Now, we all know that conclusory allegations would fail. We've all seen from pleadings in construction delay cases that a party cannot simply say, I was delayed on the project, things happened, and they were unanticipated, or they are fundamental breaches of obligation of the contract. Here in this case—
So this is Judge Kern. Even though it is a pleading stage, isn't there a basic obligation to plead that there was an inability to access the site rather than just an inability to do the work as quickly as you wish to do it? And isn't it undisputed based on the allegations that there was access to the site, just not as much ability to do it in as quick a manner because there were only 2 rather than 3 hoists?
And this is the problem, Your Honor, what I've been having in my colleagues with the First Department for several years now. When you have a construction project and it's built into the contract, it's built in that you'll have 3 hoists, not 2. That's how a contractor gives their price for the work. If you told me that there were 3 hoists, but there were some delays one day here and there about getting up fast enough, I wouldn't be sitting here in front of you today. But you just can't take out a specific bargain for provision. There was 3 hoists, and these hoists are very, very important for the work. Daniel Barbuto, in his motion to dismiss the affidavit in opposition, clearly states we suffered 25% delays. That is something that is just not, you just can't push on the side and say it's not as fast as you wanted to. If the contract—
Again, the case law is what the case law is. So the argument does have to be framed in terms of inability to access the site. And I'm just not sure what your argument is in terms of how they were unable to access the site as opposed to have a slowing down of their work.
Well, okay. The case law for the Carino exception is not solely limited to site access. That was a couple of cases. There's no case law that says it has to be site access is denied. And that's the only item that is an exception to the Carino-Savetta case. What we have here is a situation where you have a benefit of the bargain. This is not something that should be decided by judges, all due respect, I know everybody hates that, on a motion to dismiss. These are items that industry experts need to determine whether they were sufficient to be garden variety delays, something you ordinarily expect, or something that's out of the ordinary. It is something that has to go to the benefit of the bargain of the parties. What if, let me ask you, Justice Kern, what if they gave one hoist and not two, when they were supposed to have three? At that point, would you say it's denial of site access? What if they had no hoist and my client had to use cranes and put the stuff up there and have increased its time 100-fold? Would that be denying of site access? But what the courts have done here is they've taken the commercial aspect of contracts and put it on the wayside to use just terms set forth in Carino about delays. What we have here is a specific contract provision. I need 3 hoists. Yes, Mr. Contractor, here are the hoists you will have. And these hoists are not only mentioned as 3 hoists, they give the dimensions of the hoists in the contract. If you throw that out, then what am I telling my client next time? Don't even look at the contract. They can do whatever they want, give you the hoist, not give you the hoist, and you suffer whatever damages you suffer.
Well, the
that
remedy,
can't be the case.
Putting aside, Judge Friedman, putting aside your argument otherwise, I'm not expressing a view on that, but to say that the remedy for this is very simple. You don't have a provision in the contract which says there's no damages for delay because of lost time because of hoist. The contract should have said, but if you don't give us enough hoists, then there are damages. So the remedy for the issue you raise is very simple.
No, that's not fair, Your Honor. We're going to start doing that in contracts now? Oh, I see your laughter there. There's no way.
I accept your laughter on that, but it's responsive to the point you made.
No, that's not fair. And I'm trying to be practical here as a commercial lawyer. I'm not a defense lawyer.
I understand your point. I understand the point you make, and the question is whether this failure to provide one of the 3 hoists is a fundamental failure. Therefore, yes. I understand your point. I'm not expressing a view, and I understand it, but I understand your argument.
What am I telling? Let me ask you a question. And I did this the Second Circuit a few months ago.
Counsel, you can't ask us any questions. We ask you questions. No. You. This is your second time asking questions, but it's our job to ask the questions, which is fortunate. We don't have to answer your questions.
If you're being rhetorical, it's okay. If you're being rhetorical, it's okay. But Judge Kern is right. You can't ask us the questions.
It's just a frustration. I've been practicing construction for 30 years. And all of a sudden, 4, 5, 6 years ago, this department has basically thrown out almost every case on a motion to dismiss for delay damages. Now, Justice Kern...
Delay damages is a very specific body of case law, and under the Court of Appeals precedent, the exceptions are extremely narrow, which is why they keep getting thrown out. That if you want to have, I mean, you were laughing at what Justice Friedman said, but if you want to have the protection based on this pretty draconian case law, then you have to specifically create them.
Oh, that is... At what point... my problem is I've read every case in the First Department on delays. There is no guidance at what is a sufficient pleading. There's nothing there. I just don't understand what to say anymore, because they've pled. If the contract did not specifically have the 3 hoists.
Counsel, if they said you couldn't come into the building because of COVID, sorry, you denied access to the building, that would clearly fit into the exception. And that is how the case has evolved. So you have to fit into that framework.
Oh, I don't agree with you, Your Honor. I just don't. If you look at all the case law, you don't see examples of what is an exception or not. I honestly think the First Department, like the Second Department, has gone too far on the motions to dismiss. I mean,
your time is running out. So if there's something else you want to say, I want to give you that opportunity. You don't have to.
I don't have to. I think you got my point, and I just asked the court not to limit to site access itself, please.
Whether we end up agreeing with it or not, it's been well stated. Do any of my colleagues have any further questions?
Please.
Respondent?
Good afternoon, Your Honors. May it please the court, my name is Jonathan Krukis on behalf of the respondents. Your Honors, this case...
Judge Friedman, what is your response? I mean, the point you make seems... Again, whether we agree with it or not, I don't mean to say, but seems like a fair enough point. You're supposed to provide him with 3 hoists, and then you provide him with only 2. Why isn't that a fundamental failure?
So, Your Honor, I think there's a very important distinction between, obligations under the contract and fundamental obligations under the contract. The Court of Appeals in the Carino case made clear that a fundamental obligation is one that's inherent to the performance of the contract. You can't perform the contract without it. And in that context, it's not just any sort of run-of-the-mill obligation. Otherwise, you're going to have every subcontractor, every contractor in the
That's
city.
his very argument, counsel. Excuse me for interrupting you, but this is Judge Mazzarelli. That's his very argument, that he can't perform the contract, his client can't perform the contract in the time period because of the lack, you didn't provide the proper number of hoists. And they did their calculations on the timing of the work, the cost of the work, based on your providing those 3 hoists.
Your Honor, their allegation in the amended complaint is that there was a lack of productivity. They don't allege that they weren't able to perform the work because they were able to perform the work. The issue is these are sophisticated parties who entered into a commercial agreement knowing full well what was in it, and it was for their mutual benefit. The appellant accepted the benefit, performed the contract, received nearly $1 million before change orders, and now is trying to renegotiate the less convenient portions. These aren't, naive contractors and naive owners. This is a very major construction project with major construction players in the industry.
If he had only completed 2/3 of the work because there were only 2/3 of the hoist supplied, what would your position be?
Well, Your Honor, their remedy and going to the contract, we're not saying that there's no remedy for the appellant. Certainly, in the contract sets forth that their remedy is an extension of the project time. It's not a situation where they're going to have 8 months to complete the project, and if there's some sort of delay, that they're going to get penalized and that they're going to have a claim against them. They have a right to an extension of time to complete the project. The key here is that the parties entered into this agreement and they understood exactly what they were bargaining for. And Your Honors, just to speak to the actual pleading standard, at issue here, this case has been briefed numerous times now below and now on appeal. And the issue is that plaintiff continues to insist that it must merely satisfy a liberal pleading standard. There is established and extensive case law in this department which sets forth that a party has a heavy burden to demonstrate the applicability of one or more of the Carino exceptions. And that just simply isn't available here. And that makes sense because, Your Honors, this is not a run-of-the-mill breach of contract claim that plaintiff can assert and rely on the prima facie case. They are trying to assert a contractually barred claim that they have no right to bring, and they have to go and establish exactly how and set forth and cite alleged specific allegations in the complaint that shows how this is a breach of a fundamental obligation of the contract. Again, they allege that there was a lack of productivity. They don't allege that they weren't able to finish the project or they weren't able to perform the work. And Your Honors, what makes this even more applicable is that there is a very specific no damages for delay provision in this contract. It's not just simply, there's a number of no damages for delay provisions in this contract, but our client, is an established construction manager. They develop their contracts over time based on circumstances, and they wanted to make sure that, especially with the hoist, that there weren't going to be delay claims. The reason is that in a construction project, things change. There's different sequences, there's different trades on site. Certainly, you can't have 3 hoists on the project the entire time because you can't finish the exterior of the building where that hoist is. At a certain point, you move to an internal elevator. So the issue is, nobody wants to sit there and be bound by something and find out that with a small change, that 10 different trades on the site are all asserting delay claims. So that's why these sort of provisions are very important. It's very important not only for all the parties, but it's important for our client when it goes and hires trade contractors for its projects, that it understands what the parties' rights and remedies are. And in this situation, the appellant, the same way that the respondents are planning their project and they're negotiating these terms into their contract, the appellant is also considering that when they agree to enter into the contract. They understand that there's no damages for delay provisions that are in there, that there's certain things that they're not going to be able to seek any sort of financial remedy for, and they understand that. They go in with all eyes open.
Counsel, your time is sort of up. It's past the time, but do any of my colleagues have any further questions? Thank you both.
Thank you.
Thank you, Your Honors.
People versus Anonymous.
Good afternoon.
Appellant, go ahead.
Good afternoon. My name is John Palmer, appearing on behalf of the defendant appellant. This appeal concerns a 16-year-old boy charged with murder. And to this day, we do not know what counsel said in advising him on pursuing cooperation and a guilty plea hours after his arrest. The motion court could not have made an informed and prudent determination on the plea withdrawal motion without holding a hearing. This court should remand the case for proper consideration of the motion. The circumstances here present a genuine factual issue as to the voluntariness of my client's decision to cooperate with the prosecution and ultimately plead guilty.
You do have an affidavit here from counsel who represented the defendant at the plea, is that correct?
Yes. And in that affirmation, he does not deny reluctance to try the case, as the plea withdrawal motion alleged, nor did he elaborate on what he told my client about cooperation at arraignment when he first decided to pursue that action.
Well, but one of the things is I think that the claim is made that there's an alibi, or perhaps an alibi, and he says that he was never told that there's an alibi. Is that so?
He was not. That's what his affirmation says. The client's affirmation does not allege he has an alibi. He just says he maintains his innocence and that counsel did not want to try the case and that his pressure and coercion led him to make up a story to cooperate with the prosecution and plead guilty. Now, counsel's affirmation does mention that he discussed things like exposure and alternatives with my client during the arraignment interview, but he does not provide the substance of that discussion or how he presented information beyond saying that it was his choice,
Doesn't
not
he
mine.
refute this claim of coercion?
He does say he did not pressure my client into pleading guilty. But what you or I may perceive to be not coercive, either as the person on the receiving end of the discussion or the person providing the advice, that may not be the case for a teenage boy with a 10th grade education. This is not a case where we know exactly what counsel said, where we could say, oh, it was merely a warning of the risks of trial, or that counsel provided frank advice, right? And a complete understanding of counsel's representation and its effect on my client is especially important here, given my client's age at the time of the offense, his decision to cooperate and take a guilty plea, as well as the seriousness of these charges here. We know that juveniles are more likely to provide false confessions.
So what does the defendant say that shows he was coerced?
He says in his affirmation that his attorney did not want to try the case and he was pressured and coerced, or as a result of his pressure and coercion, he made up a story in order to cooperate with the prosecution.
Mr. Palmer, this is Justice Kennedy, if I may. What about the fact that the defendant and his relatives spoke on numerous occasions with Mr. Sundin, and at that time never indicated that he was innocent, never indicated that he was being forced to plead guilty, and certainly repeatedly stated before the trial court that he read everything, he understood everything, and he was pleading guilty voluntarily? What about that?
Well, Your Honor, the discussions with my client and his relatives between arraignment and the plea and thereafter are worth exploring at a hearing. And as far as his statements on the record at the plea proceeding, this is not as straightforward of a case as someone saying, oh, I didn't understand, but they said that they understood on the record at the plea. Here, there was a plea withdrawal motion.
When you say there should be a hearing, don't you need to have some factual issue, some factual conflict, which leads to the need to have a hearing?
Yes, there is a genuine factual issue here as to counsel's representation and his advice to our client on cooperation and the decision to plead guilty at the time that he made that choice, which started all the way back at arraignment. And without further elaboration and facts on the substance of that conversation, and the following conversations and how they were presented and received by counsel and my client in an informed and prudent determination could not have been made without a hearing. And for that reason, this court should remand the case for appropriate consideration on that matter.
Do any of my colleagues have any further questions? Respondent?
Good afternoon, and may it please the court, Jennifer Westwell for the people. The court below appropriately rejected defendant's plea withdrawal request without a hearing. The court hardly gave short shrift to defendant's motion. There was a lengthy record leading up to the denial of his request, and the court provided defendant ample opportunity to present his arguments, even appointing substitute counsel for this purpose. Despite this opportunity, defendant proffered exceedingly vague and shifting reasons for seeking to withdraw his plea. My opponent says that defense counsel should have been called in a hearing to clear up these factual issues, but it's unclear exactly what defense counsel could have been asked. That defendant could not have sworn to in his own affidavit. The salient inquiry is the effect on the defendant, not what defense counsel actually said. Furthermore, it is hard to give any credence to defendant's newfound claims of innocence when he attested to his guilt under oath, and before that, he had repeatedly and to numerous parties admitted to participating in the murder. And he did so before his attorney's involvement in the case even began. Given this record, the court below recognized that there was nothing factually to develop at a hearing, and it acted well within its discretion in summarily denying defendant's motion. Unless there are any questions, we ask that you affirm.
Do my colleagues have any further questions? Mr. Palmer, go ahead. You had a minute to respond.
Thank you. I would just like to add that respondent says that there was a well-developed record prior to the court's denial of the motion, but it's not like there was a opportunity to reply. There was no inquiry here. There was no invitation of further argument in order for new counsel or our client to respond to the allegations in the affirmation. And further, this is not as if it's in a situation where it's like a motion to dismiss or a motion to suppress, where there is a clear-cut burden of proof here. After the motion and the response from the people, including the previous attorney's affirmation, there remained a factual issue as to what he said to our client in advising him on cooperation and guilt in the guilty plea. Thus, we ask that court to remand the case for a hearing on the motion.
Do any of my colleagues have any further questions? Thank you both.
Thank you.
Both. People versus Torres. Appellant.
Good afternoon, Your Honors. I'm Benjamin Weiner on behalf of Appellant Angelo Torres. Within 6 seconds of being chased out of the Chelsea Wine Country liquor store, Mr. Torres had been wrestled to the ground by 3 or 4 clerks, and the bottle that he had been stealing was broken. Under those circumstances, the prosecution failed to prove that he used any force with the conscious object of retaining the bottle, as opposed to simply trying to avoid being tackled and arrested. As an initial matter, the prosecution failed to prove that Mr. Torres hit Vega, the clerk, on the head with the bottle, at least intentionally. Mr. Torres was acquitted of causing physical injury, and he was acquitted of using a dangerous instrument. And even Vega himself admitted that what Mr. Torres did could have been accidental. And that was entirely consistent with the other clerk, Torres' testimony, that Mr. Vega hit Mr. Torres on the head as he was slipping and falling. So all that really remains is Mr. Torres' struggle to evade the grasp of these, again, multiple men who are violently accosting him and trying to wrestle him to the ground. And that set of circumstances just does not give rise to an inference beyond the reasonable doubt that what he wanted to do in that moment, his conscious object, was retaining the bottle. To the contrary, the much more natural inference is exactly what Mr. Torres testified to, that he didn't want to be tackled, and more importantly, didn't want to be arrested. Mr. Torres is somebody who had been arrested before. It's not surprising that he runs into this liquor store. It's a very unsophisticated theft. It really is a petit larceny. And he gets in too deep and just wants to get away at that point. And two significant facts support that. First of all, the bottle broke. Mr. Torres failed to retain the bottle. And second of all, even after the bottle was broken, Mr. Torres continued to struggle to try to get away from these clerks, indicating that, again, as was sort of the natural assumption here about what a person in Mr. Torres' situation would want, what he really wanted was to avoid being arrested. And again, this is reflected in his testimony on page 193. He says, "It happened real quick." When he's asked, "Were you trying to get away with the bottle of vodka?" This is on page 195. He says he was trying to get away from them holding me. In his direct testimony, he said he was really trying to get away and was not trying to get arrested. This is exactly what you would expect from a person in Mr. Torres' situation. You would expect him to try to get away and to be indifferent as to whether he retained this bottle of vodka that he had stolen. And that's all that the evidence proved here. It did not make out his conscious object to retain the bottle, and that was necessary to prove his guilt beyond a reasonable doubt.
Well, didn't one of the complaining witnesses ask him, this is Judge Mazzarelli, a couple of times, or demand that he drop the bottle? Didn't they tell him that, to put the bottle down, drop the bottle?
So what I want to emphasize here is that this happened. Vega admits that Mr. Torres is on the ground within 6 seconds. In the video, you can see these clerks chasing him out of the store. Vega admits that he grabs Mr. Torres before he uses any force. So there was no time for a polite exchange here. These clerks were determined to wrestle Mr. Torres to the ground. There was no time for him simply to return the bottle and be on his way. That was never going to happen here. And what the circumstances indicate is that Mr. Torres was chased, that's the way these clerks reacted, was to chase him and violently wrestle him to the ground. And there was simply no opportunity for him to return the bottle under these circumstances. I do just briefly, does Your Honor have a question? Sorry.
Well, you keep talking about the clerk's violent behavior, but your client wasn't exactly compliant and cooperative, and he was violent himself.
Well, he's trying to get away as he's being wrestled to the ground, Your Honor, by four men are trying to wrestle him to the ground.
All he had to do was stop and put the bottle down. That would have been the end of it.
But they're grabbing him and wrestling him to the ground, Your Honor. It wouldn't have been the end of it. He would have been wrestled to the ground and he would have been arrested. And an intent to do those things, an intent to use force to do those things, merely to get away and merely to not get arrested, is just not sufficient in this case. It has to be an intent to retain the bottle, and that just wasn't made out under the circumstances here.
Do any of my colleagues have any further questions? Counselor, thank you.
Thank you.
Respondent.
Good afternoon, Your Honors. Samuel Goldfein on behalf of the people. I guess I would start just where Justice Mazzarelli ended. Defendant was told by Vega. So Vega chases after the defendant. He grabs him by the shoulder, drop the bottle. Defendant says no. And he tells him, if you drop the bottle, I'll give you. If you give me the bottle, I'll let you go. And defendant, in his own testimony, admits to that. On 197, he said he admits the question. You were asked to give the bottle back. Answer correct. He's aware that he could just give this bottle back and go his way. But as defendant himself testifies, that's not his goal. He wanted to hold on to the bottle and get away with it. Counsel pointed you to 195, where defendant just says, I was trying to get away from them holding me. Yes, but at the bottom
Is
of
this the first time that this person was arrested on these premises?
On these premises, I'm not certain, Your Honor, but on this record, yes, this is his first arrest at this.
Because to me, it's very puzzling why these three clerks would be so invested in apprehending someone who stole one bottle of alcohol. I mean, they don't know, if they don't know him, they don't know what kind of weapon he could have or what kind of risk they could be facing. It was quite a set of facts that I found somewhat mystifying.
Well, I mean, I can't speak to the clerk's reasons for chasing after the defendant if they were concerned of trouble for their bosses, but suffice it to say is they did chase after him. They grabbed him. They asked him to return the bottle or demanded. Defendant refused. He started struggling. At that point, I mean, he's using force to overcome resistance to the taking. He then raises the bottle above his head.
Well, opposing counsel says he's using force to overcome to overcome being arrested, not to overcome keeping the bottle.
Well, Your Honor, I would say two things to that. Well, three things. There's the presumption in Gordon. Defendant is still in possession of the stolen property while using force. The presumption is that he's using force to retain the property. But number two is defendant's own testimony. At the bottom of 198 going into 199, the question, and you're still holding the bottle. Answer, still holding the bottle. Question, you hadn't let it go? No. Question, because you wanted to get away with it, right? Answer, correct. So by defendant's own testimony, he's holding on to the bottle because he wants to get away with the bottle. And again, to Your Honor's point, defendant admitted that he was told, I'll let you go. And he doesn't do that because, as his own testimony confirms, he wants to get away with the bottle. The fact that he broke is, I think, irrelevant to this crime. He was successful in striking Vega in the head with it, and the bottle didn't break. And maybe not the wisest decision, but the bottle was successfully used as a weapon here. It only broke when defendant dropped it to the ground after using it as a weapon. So I think here on these facts, defendant plainly stole this bottle. He got caught, and he used force to try and get away with the bottle. Whether he wanted to escape arrest as well, that's reasonable. But he's trying to get away with this bottle of vodka, and he struck Vega in the head.
Do my colleagues have any further questions? Thank you. Appellant?
Thank you, Your Honor. So as to him wielding this bottle, what Vega testifies is that he makes to throw it at Torre, who's the other clerk on the ground. That's completely inconsistent with an intent to retain the bottle. You would never throw something away that you wish to retain. The facts here, again, permit a doubt as to whether a reasonable doubt as to whether he intended to retain the bottle. And I would just say, if this is a robbery at all, it is absolutely the least significant robbery that is imaginable, given the fact that he didn't cause physical injury, given the fact that he wasn't carrying a weapon. This was a shoplifting gone bad. And given Mr. Torres' circumstances, we would respectfully request that the court consider reducing his sentence to the absolute minimum, because if this case doesn't warrant it, it is very difficult to imagine a case that would. Thank you, Your Honor.
Defendant is currently on parole supervision, right?
That's right, Your Honor.
Any further questions by my colleagues? Counselor, did you do this on a pro bono basis?
I did not. I worked with some very, very able pro bono volunteers who unfortunately were unable to do the actual oral argument.
Okay, because I saw it was originally slated to be a pro bono case, or at least pro bono attorneys were on it. So if it was, I wanted to thank you, but I want to thank you for your time and service anyhow, as I do the assistant district attorney who responded. Thank you both.
Thank you, Your Honors.
Thank you.
Thank you, Your Honor.
At this time, court is adjourned. That concludes oral argument today.